name is Nick Weiss. I am the founding and managing attorney of Weiss Law with offices in South Euclid and Elyria, Ohio, serving the greater Cleveland area. I want to talk today about deciding when you need to actually push forward with a divorce, the divorce filing. In other videos, we talked about the different ways that you can dissolve your marriage, whether it's by legal separation, whether it's by dissolution, or whether it's by divorce. I want to get a little bit more specific on when we would advocate for proceeding with a divorce and what the circumstances are and what you can expect when we do that. The important thing to remember is that divorce is a process. It's a procedure. It's a legal process where we go step by step, like any other litigation, to try to get to a full and fair resolution, division of assets, debts, income and expenses, parenting plans, child support, spousal support, and division of all of that on a fair basis. When people call in asking whether they need a divorce, I have a couple of questions that I ask them. The most important question usually is, what is the level of cooperation between the parties? Has communication broken down? Do you know what they're doing? Is someone hiding things from you, whether that's finances, whether that's healthcare information, whether there's things doing with the kids? If we have a full and fair disclosure of things, if we have open communication, then I'm going to suggest that we try one of the other less confrontational, less acrimonious ways of dissolving a marriage, like a dissolution, for example. But if we have unreliable parties, and by that I mean maybe they're moving money around, right? Hiding assets. Maybe we have unknown expenses that we don't know about, increase in credit card debt that is not being disclosed. Hoarding, right? Hoarding the finances, not letting one party have access to the bank account or to the credit or something else, where we've got some kind of economic or even physical coercion. I'm going to push for divorce on that one. Usually when we have those processes in place, when we have those factors in place, it's because dissolution won't work, right? Because to get to dissolution, to do the easy way of dissolving a marriage, you need full and complete disclosure on finances, on children, on health, on everything else that's on there. And if you've got someone who's hiding things already, that's just not going to happen, right? So now we have to go through the process. Now we have to file our complaint for divorce. And that doesn't have to be scary. What we're trying to do is get information that they, in some cases, refused to provide to you prior to the divorce. Whenever you file a divorce, it's a mandatory disclosure at the beginning of a case. All of the assets, debts, income, expenses, right? That each party has to give. And if they don't do that, and we're doing our jobs, the court can compel them to do that. And then the court can punish them if they don't do that. Oftentimes by, if they violate the order, they can get an adverse inference against them. So we can ask the court to believe certain things about the case and about the assets of the parties because the other side just isn't disclosing that, right? That's the biggest hammer that we have in order to get that. The other time we might suggest divorce is if there is disclosure, but the assets are particularly complex, right? We're talking about multiple businesses, multiple investments, high value stuff that it would take some time to unravel, either through a forensic accountant or CPA or something like that, where we're going to have to retain experts anyway, right? We're going to have to go through that process. And many times getting access to those documents will require a subpoena, will require a court order, something along those lines, right? So if it's particularly complex, and especially if we're on time crunch, we might suggest filing for a divorce just to get that additional judicial power to get the information we need to get to a resolution. If the process keeps stalling, nothing gets finalized, right? We think everyone made a full disclosure, and someone's dragging their feet, and this happens a lot. And I'll tell people at the beginning, because we price our dissolutions and our divorces differently. If we get to the end of a deposit on a dissolution and we're not done, it usually means the dissolution is not going to work and that we have to go to divorce. Someone either is hiding something or, and this happens a lot, they just don't want to get divorced. And so by drawing out the process, by not signing the final documents, et cetera, they can avoid that, right? And so then we got to file. This is important because you do not need agreement in order to get divorced. One person can file and the other person doesn't agree. That's why we have trials. That's why we go to the judge and say, here's how the division should go. Most of the time, we don't get that far, right? We don't actually get to the trial because the person who is holding out, maybe not disclosing assets, really doesn't want to get divorced, blinks. Litigation is expensive. Litigation is difficult. Litigation is exhausting for everyone except us, right? To go through and disclose in public, because all this is public record, all of the things relating to their marriage to do this. Most people don't actually want to go through the whole process. A very, very small minority of our divorces that we file actually go to trial. Most are converted to an uncontested divorce, and then we submit an abuse judgment entry, and then we're done. So really, the questions are, if we're deciding whether to file for divorce or do some other method, are, do we have a full and credible financial disclosure? Can we make decisions quickly, without delay, without avoidance, et cetera, and this is big, can both parties follow through on what they agreed on? At the end of the day, a divorce judgment is just a piece of paper. If we enter into an agreement and you have a pretty good idea they're not going to follow it, then what are we doing? Why are we going through this process when we could just get our judgment and then enforce it immediately with the court? That's the bare bones stuff. There are a lot of other factors that go into the choice of what process to use, whether that's by divorce or whether it's by dissolution, whether it's by legal separation. And ultimately, we can help you choose the process. We can't help you choose whether you are ready to dissolve your marriage. That's an emotional decision. That's a life decision. That's not a legal decision, right? You're the one who has to make that choice. But what we can do is guide you through which process we think is going to maximize your best interests and the best interests of your family. So if you have more questions about this, please feel free to reach out to our office. We're happy to talk with you further.